Food and shelter. Yeah, food and shelter is standard. It used to be food, shelter, and clothing. They removed clothing about 6 or 7 years ago, so we can use it for clothing now without changing benefits. So that's kind of designed really to give you an introduction into some things we can do with trust. Now you'll notice a couple of things. If I create a revocable trust, I'm doing some nice things. I'm avoiding probate, I'm avoiding conservatorship, but I'm not getting creditor protection. We have a lot of clients out there that think that they've got creditor protection because, my assets are in a trust. I'm not worried about Medicaid, all my assets are in a trust. And we say, well, let's look at your trust, and only to find out they've got no protection at all. It's in a revocable trust. Creditors are entitled to whatever you're entitled to. And so if you have a legal right to demand an asset, they have a legal right to demand it on your behalf. If you have a legal right to make changes to the trust to then claim it, they have a legal right to force you to do that as well. And so revocable trusts don't create any or give any creditor protection to the grantor of the grantor or beneficiary of the trust. Irrevocable trusts may or may not, depending on how they are drafted. The general rule in Mississippi and in most states was that if you created an irrevocable trust that you yourself were also the beneficiary of, it had no protection. And that was a common law rule that kind of developed over time, because it's really not fair for me to create a trust, make myself the beneficiary of the trust, move my assets into it, say, I'm not going to pay you because my money's in trust now, and so that trust I created can only pay me for certain things. It doesn't include creditor claims. Well, that doesn't seem quite right. And so we had public policy against that until the 1990s and the 2000s, when we had several states start to experiment with allowing certain types of irrevocable trusts to be exceptions to that rule. And so we'll talk about the move around the country to allow beneficiary-created irrevocable trusts, and if they're formed properly, trusts that are not subject to creditor claims. 14 states now have enacted domestic asset protection trust statutes. And you notice the last one on there is Mississippi. Mississippi's went into effect July 1st of 2014. We call ours something different, by the way. Every other state that I'm aware of calls it the Domestic Asset Protection Trust Statute. Ours is called Qualified Disposition in Trust Statute. I know no reason as to why ours is named something different, but it is. And what it does is it gives us now, or gives our clients, the ability to self-create a trust that, if it's formed properly, will not be subject to creditor claims, even though the creator of that trust may be a beneficiary of that trust. Again, there's a lot of exceptions as to how that's done, but you've got to have a qualified trustee. Qualified trustee in all of these states means a trustee in that state. So what these states are doing is they're trying to create trust business. They're kind of trying to generate economic activity within the state itself. And so one of the requirements of these types of trusts is you've got to have an in-state trustee. It's got to be funded with qualified property, so certain types of property that different states will allow to be put in, other property that won't be allowed to put in. The trust does have to be irrevocable, and so unlike the trust that I created for Bill and Mary, they reserved the right to make changes to it along the way, so nothing was really final until they died or lost capacity. These types of trusts have to be irrevocable from the formation. And that's a good reason for that, because if I could change it to say something different, then why can't I change it to make that creditor a beneficiary of it? And so it does have to be irrevocable. And it has to be formed under a state's statute that allows for domestic asset protection trust, those types of trust. They're a specific type of trust. The governing law should be the state where the trust is found. We have in the law something called choice of law rules, where if we have a case that involves multiple jurisdictions, there's a toss-up into, well, how do we treat this? Do we do it under Mississippi law? Do we do this under Wyoming law? And so the general rule, and the rule in Mississippi, is that when a trust, the interpretation and governance of a trust is governed on the trust of the state of formation, not where the beneficiary resides, or not where the property is. And so that's a general, almost universal rule for trust, and that would apply in these domestic asset protection trust circumstances as well. Different states allow different powers for the grantors, and we'll look at Mississippi's in particular. The reason we look at different states is because we kind of have a choice of where, if we had clients wanting to form these, we don't necessarily have to use Mississippi's statute to form it. We can go to Tennessee and use their statute. We like theirs better, perhaps. Or we can go to Wyoming and use their statute, or we can go to Nevada and use their statute. And these statutes are different in different states, and so we need to kind of have some familiarity with them before we actually make a selection as to what to do. But these are kind of some common issues between between all of these states is with respect to how these trusts operate. The trust can have an investment advisor. So again, you can split that role between the trustee and the person in charge of the investments. And the investment advisor frequently can be the creator, the grantor of the trust. And so that's a good thing, because I create this trust, and the assets I'm putting in there are my timberland, and the assets I'm putting in there is the LLC I've got for this business that I'm operating. And I want Mr. Trustee to be doing the fiduciary stuff, and I want the trustee to file the tax returns, and I want the trustee to be able to send me money if he needs to out of there. But I don't want the trustee running my business. I don't want the trustee deciding when timber's going to get cut. That's me. I'm going to decide that. Well, I can name myself as Trustmaker in most states. I can name myself as the Trustmaker as also being the investment advisor. And now I get to vote the shares to decide who the managing member of the LLC is. I get to decide when we sell trees or not, at what price we sell trees. That's an investment decision that I've reserved for myself. And that's permitted in most states that allow these types of statutes. One unique state that you ought to be familiar with is Wyoming. And I say unique because in every state that has these, you've got to have an in-state trustee. An in-state trustee in every state but Wyoming means a bank or trust company or an individual. But Wyoming defines the individual more broadly than most states do. And Wyoming defines an individual as a person or an LLC. And so in Wyoming, we can actually create a trust like this, and we can also create an LLC that can serve as the in-state trustee of this Wyoming trust. So I got an out-of-state beneficiary over here that has control of the in-state LLC that serves as the in-state trustee of this thing. So for some clients that are real concerned about giving up control, we've used Wyoming as a jurisdiction because we feel comfortable with being able to have control or have an influence over the trustee more than just by hiring them. Qualified property, real property, personal property, appreciation, income, gains, what is not qualified property. IRAs are not qualified property. You can't move an IRA into one of these trusts. In most states, including Mississippi, the trustmaker has to sign an affidavit stating different things. It's a good practice anyway for the lawyer involved in creating one of these to make clear that they're not thwarting creditors, but in a lot of states require that anyway. They've got to sign an affidavit saying that they have the authority to transfer the property, that it's not making them insolvent, that they're not defrauding creditors, they're not planning on filing bankruptcy, they're not in default of child support, they're going to maintain $1 million liability policy. That's a requirement in Mississippi that I don't know of any other state even has. But in Mississippi, they require you to have $1 million of like an umbrella general liability policy. They also make you have $1 million of malpractice coverage if you're a licensed professional. So that's one difference in Mississippi. Many, but not all, of the domestic asset protection trust statutes have exceptions for creditors for child support, for marital support, and certainly for fraudulent transfers. All of them have it for fraudulent transfers. But many of them have exceptions for these others because it doesn't look good to have someone move their assets into a trust and then not pay their child support, and then that doesn't seem quite right. And so for most states, but not all, those are exempted claims from that. A fraudulent transfer in all jurisdictions is going to be a transfer that the debtor has made with an actual intent to hinder, delay, or defraud creditors. And so we're not going to let people create these trusts, move assets into it, and say, creditor, you can't collect this. If moving those assets made them insolvent, if moving the assets made it more difficult for that creditor to collect on a debt, they can likely have that transfer overturned because it is a fraudulent transfer. There are statutes of limitation as to when you can challenge that. Different states have different statutes of limitation. Mississippi has, is among the most liberal in the country with the statute that we passed. It's a 2-year statute. It's actually 2 years or 6 months from actual notice, whereas most states use a 4-year statute of limitation. So, and from that sense, we have a pretty progressive statute. Who's going to be the trustee? Family members that live in the state can be trustees if you wanted to. You can name friends if you wanted to. Professionals, CPAs, individuals can serve as these, or corporate fiduciaries that are licensed to be a fiduciary in the state. In Wyoming, that's what you would do, is create a private trust company as an LLC in that state to serve as trustee of that one trust, and you can have a little bit more control over the trustee, and perhaps a little more control over expenses as well. The best states for domestic asset protection trusts, generally Nevada is really seen, I think, as probably the best state. South Dakota is a very good statute. Wyoming has that unique bend on it of letting you create your own LLC, so that's interesting. New Hampshire and Texas have pretty good statutes. Tennessee actually has a pretty good statute. Mississippi's is kind of middle of the road as far as the protections that we get. The real problem with Mississippi statute, I think, is that we've got this umbrella policy requirement and this professional liability requirement that I understand while it was well-intentioned, the idea is not going to be fair to move assets over and then you wind up with a lawsuit and no money to pay the claim. So if you're going to do this, we want you to at least have liability coverage. That assumes you can get liability coverage, though. And so if we create this thing, move assets over, got $1 million umbrella policy, but then I have a little fender bender, then I have another little fender bender, and it's not going to take another fender bender before I get a notice from State Farm that says, hey, we're not going to renew your umbrella policy next year. You no longer represent a good risk to us. Well, Mississippi statute says if I lose that policy, $1.5 million of my assets in this domestic asset protection trust are now unprotected. And so it kind of defeated the purpose of doing it. So that's a real weakness, I think, in our statute, and frankly, probably going to be one that causes most people not to use Mississippi statute, is my thought on it, because that's in there. There's also an exception for tort creditors, were pre-existing tort creditors, whether you had notice of them or not. And so again, that's a risk that you don't have in these other jurisdictions that you do have in Mississippi. And so for that reason, I think that it's a less desirable statute than some of these others.
Are we having a break or not?
We can take a break. Would y'all like a break?
Yeah, as a matter of fact.
That's a good idea.
All right. Well, y'all come back and then we'll finish talking about those.